Hi, my name is Barry Doyle. I'm a personal injury and workers' compensation lawyer in Chicago. Today we're going to be talking about whether or not owner-operators can get workers' compensation after an on-the-job injury and three surprising facts about that. The information we're going to be talking about today is important for owner-operators to help them protect their rights after an on-the-job accident. If you can hit share so that people in your network can get this good information, that would be helpful. It is important because owner-operators are carrying a big burden when they're paying for a truck and trying to run their own business, and their income gets cut off because of an on-the-job injury. And the fact is that they have more rights than you might ever think in terms of workers' compensation after an on-the-job injury. One of the things that owner-operators are always told after an on-the-job accident is, hey, you can't get workers' comp at all. You're an independent contractor, and that makes sense. Workers' comp is available for people who are employees, and when you sign on with a company as an owner-operator, you sign an independent contractor agreement, and to some extent it stands to reason that you really aren't eligible for workers' comp. But the fact of the matter is that it's an issue that the Illinois Supreme Court has looked at in the context of what does the workers' compensation system allow, and when the company is telling you that you can't get workers' comp because you're an independent contractor, they very well may be wrong. And here's the deal with that. The Illinois Supreme Court has taken a look at the issue of whether or not owner-operators can get workers' compensation. The answer that they gave ultimately is it depends. It depends on what the facts are. But it looks past the contract that's there, the independent contractor agreement, and looks to the substance of what is actually being done. People who are owner-operators are doing basically the exact same work that people who are on the payroll of the company are doing. The work that they're doing, sits right at the heart of what a trucking company does, and the trucking company, to a large extent, has to maintain control over what the owner-operators do if they're going to stay in compliance with the federal motor carrier safety regulations. So the Illinois Supreme Court looked at those three things. Is the work that you're doing similar to what a payroll employee does? Is the work that you're doing at the heart of what the company actually does? And does the company have to maintain control over the work that you do? And if there's sufficient evidence on each of these 3 points, then in fact you may be found to be an employee for workers' compensation purposes, and that means that you're eligible to get workers' compensation benefits, which includes 2/3 of your average weekly wage while you're off. It includes getting your medical expenses paid for. It includes getting a lump sum payment for permanent disability that's associated with the injury. So, when the company tells you you're not eligible to get workers' comp, they may be wrong, and in fact they probably are if you're doing the same kind of work that people who are employees of the company are doing in the same kind of way, just with a truck that you happen to own. So that's, I guess, surprising fact number one is that even in the face of an independent contractor agreement that you've signed, the Illinois court system may take a look at the work that you do and decide that for workers' compensation purposes, you're an employee and you're eligible for workers' compensation benefits. So when the company's telling you no, they very well may be and probably are wrong in that regard. The key thing about this issue of whether or not you're an employee or not for workers' compensation purposes is that it's considered a question of fact, and that's a legal term that has a very specific meaning. Question of fact is anything that can be disputed, okay? So if we take, for example, a question of, did somebody run a red light or not, and the person who's driving says, no, I didn't run the red light, but there's a witness who says, yes, you did. It's a question of fact, and somebody who's a finder of fact in the workers' compensation system, it's an arbitrator, has to make a determination as to which witnesses they believe. Now, once that finding of fact is made, because somebody has had the benefit of seeing the witnesses and hearing the evidence, once you get past the trial level and try to appeal things, those findings of fact are almost never ever reversed. So the key point for anyone who is looking to make a workers' compensation claim as an owner-operator is that this issue of whether or not you're an employee for workers' compensation purposes is a question of fact, which means that you have to get it right the first time. If you go ahead and present a case and you don't put on the right kind of evidence as to those key issues that we talked about, the kind of work that you're doing, the relationship of the work that you do to the business of the company, and the degree of control that the employer exercises over you, and there's an adverse finding for you. In other words, they find that you're an independent contractor and not employee for workers' compensation purposes. it's almost impossible to get that decision reversed, which means when you present it the first time, it has to be done right, which means that you need to get good legal help who knows what they're doing to put that on. So that's, I guess, surprising fact number 2 is that this issue of whether or not your employee is, it's not always a clear-cut one, and you have to get it right the first time. If it's something that you end up having to appeal, you're fighting a steep uphill battle. Okay. Surprising fact number 3 is that not every state views this issue the same way as Illinois. Workers' comp is a different system in every state, and there are some states which specifically exclude owner-operators from coverage for workers' comp. Now, in Illinois actually offers coverage in their workers' compensation system for accidents that happen outside the state of Illinois. There's 2 particular situations where they do that. One is when the contract for hire is formed in the state of Illinois, and that's a fairly complex issue as to like where the actual contract for hire was formed, but basically it's where the last thing that happens that needs to be done to create an employment relationship. So, if you went into a clinic in Illinois to pass a physical, and that was the last thing that you needed to do, that may be enough to bring your case into the Illinois workers' compensation system, even if you live outside the state of Illinois and the accident happened outside the state of Illinois. The other situation where Illinois extends jurisdiction to accidents that happen outside of Illinois is where your principal place of employment is inside the state of Illinois. So if you have a home terminal or dispatch center that you're is considered technically your home base or your home terminal or whatever terminology your company uses, even if you live outside the state of Illinois, the accident happens outside the state of Illinois, if your home terminal is in the state of Illinois, that generally is enough to confer jurisdiction over the Illinois workers' compensation system. So you can live in a state and be injured in a state where workers' compensation coverage isn't offered to owner-operators ever, but because your home terminal is inside the state of Illinois, you have at least potential to have your workers' compensation case go forward in the Illinois system. Now, the Illinois system is also one that generally is a little bit more favorable to injured workers than many other states, which means that you may get a higher level of benefits. It may mean that you have better control over your medical care, better access to quality medical care. And those are things that can make a huge difference in the ultimate outcome for you. So I guess that's the third surprising fact, is that even if you live outside the state of Illinois, even if you're hurt outside the state of Illinois, you may be able to, as an owner-operator, pursue a workers' comp case in Illinois, even if all the other states that are involved don't offer that kind of coverage to owner-operators. So our 3 surprising facts: 1, yes, owner-operators may be covered by workers' compensation. Number 2, that issue of whether or not you as an owner-operator would be covered by workers' compensation is a question of fact, which needs to be handled right by good legal counsel at the trial level. You can't, trying to appeal it's basically a futile effort. And the third one is that even if you live outside Illinois and are hurt outside of Illinois, if your home terminal or the place that you were hired out of is inside the state of Illinois, you can go ahead and make a claim under the Illinois workers' compensation system, even if the other states are involved, like where you live and where you were hurt, wouldn't offer you that same kind of coverage. So I hope this has been helpful. If you have any questions, feel free to message us. Go to our website, www.Rights of Injured Truckers, fill in a contact form. You can call our office at area code 312-263-1080. Ask any questions you might have. The call is free. There's no obligation to hire us. If you think this information has been valuable or helpful, hit like, hit share, because I do believe it's information that not everybody recognizes is true, and certainly their owner-operators are being told, no, you can't get workers' comp because you're an independent contractor, and it's just probably not true. And we want to try and make workers' comp benefits available to them when they're entitled to them. So I hope this has been helpful. Have a great day. Stay safe on those roads. Take care.